Welcome to the Docketing Excellence webinar series, which is sponsored by Black Hills IP and the SLW Institute. Black Hills IP is an accurate, efficient, and cost-effective U.S.-based IP docketing and paralegal service provider. The SLW Institute is an educational group created by the Schwegman, Lundberg, and Wissner firm, which aims to provide insightful and useful information to the IP community. For this webinar series, we have pulled together docketing experts and managers from the Schwegman firm, Black Hills IP, and their respective clients and customers to help educate on key docketing challenges and issues and share best practices on how to overcome them. The Docketing Excellence webinar series is free. There are about 2 webinars per month through May 2017. To see a complete list of webinar topics and to register for future webinars, go to the Webinars tab of the Black Hills IP website, which is www.blackhillsip.com. The webinar that we are presenting today is the 6th in the series. Today's topic is common U.S. docketing mistakes and how to avoid them. We have allowed time for questions at the end of the webinar. Questions may be submitted using the Q&A button on the control bar on your screen. You can submit a question at any time during the presentation. The question will be held in a queue until the end of the presentation. The presenters today are myself, Sean Heiss, and Carrie Stewart Valadez. I'm Ann McCracken, the president of Black Hills IP. I'm a patent attorney with 19 years experience in patent prosecution. I was a partner at the Schwegman firm for 10 years. I also was a full-time law professor and directed the patent prosecution program at Franklin Pierce Law Center for 5 years. Sean, can you please introduce yourself?
Thanks, Ann. I'm Sean Heiss, the Operational Excellence Manager at Black Hills IP. I've been here just a little over a year. I oversee the docketing group here, and I've been in the IP industry for about 17 years.
Great. Carrie, can you introduce yourself?
Yes, my name is Carrie Valadez. I am an international docketing specialist here at Black Hills IP. I've been here for a little over 3 years, and in total, I've been docketing in the IP law field for about 8.5 years.
Well, thank you, Sean and Carrie, for being part of our program today. Today, we'll be discussing the following topics: foreign filing deadlines for multiple provisional roll-ups, accelerated examination, InterParty Reexamination, docketing multiple options for responding to final office action, docketing deadlines for challenging patent term adjustment calculations, docketing deadlines for submission of prior art, and docketing of notices of allowance. The first topic, foreign filing deadlines, is particular to the scenario where you have multiple provisionals filed at different times and then a PCT application or a U.S. non-provisional application claiming priority to those multiple prior provisionals. So let's say, for example, you had a first provisional application that was filed, and then a couple months later you had a second provisional application that was filed, and a couple months later you had a third provisional application that was filed. With respect to that, Carrie, can you talk about how you should handle docketing the foreign filing deadlines when you have multiple provisionals like that are rolled then together into a single U.S. application or a single PCT application?
Sure. So best practices from a docketing standpoint, if you're dealing with multiple provisional priority deadlines, is to always go with the earliest priority date. So that first filed provisional, whatever that date was, rely on that one for any kind of foreign filing or filing deadline. Also, another point I'd like to make is, as a docketer, we should never assume things. Just because a utility application has been filed claiming priority to these 3 separate provisionals, that doesn't mean that provisional filing or conversion filing on these provisionals is now done. There could be new matter in the second provisional and even different matter in that third provisional that the attorney might want to file on. So just because a filing has been made doesn't mean that more filings can't be made. So as a docketer, just rely on your attorney to clarify exactly when deadlines are no longer needed and can be removed.
Great, thank you, Carrie. Let's go on to accelerated examination. Accelerated examination, as everyone knows, does not permit the applicant to take an extension of time. So how do you make sure that what is effectively a non-extendable due date for an accelerated examination case, although if you were not in accelerated exam, there would be extensions allowed, how do you make sure that that deadline in the accelerated examination case for responding to an office action, for example, is treated as a hard deadline and not accidentally rolled forward on a busy attorney's docket who's not paying attention or even recognizing that these are accelerated exam due dates? Carrie, can you start off and comment on that one?
Sure. So the first problem with accelerated examination is notifying that you're dealing with this special case. Oftentimes the office action issued by the PTO doesn't have any designator alerting you to the fact that the case is in accelerated examination. So we will have to rely on our docketing system to help signal to us that we are dealing with a special case. Oftentimes, the first course of action will be to add a historical activity once that notice of acceptance is issued by the PTO. The problem with relying on this solely is that it'll get lost as prosecution moves forward and activities get added. You might not notice this one activity noticing or signifying that accelerated exam has been accepted. So another way, in Foundation IP specifically, they have an activity called matter management. So if you were to add a comment in this activity notifying you that accelerated examination has been accepted on this case, that would be one way to signal to you and the docketer that it should probably be docketed differently. If you don't have Foundation IP or you don't have that activity or you don't like using it, another good way to signal that you're dealing with an accelerated exam is to add a designator at the end of your attorney file number. Maybe add something like an X or an AC or something obvious to signal to you that you're dealing with a special case. If you don't like that, you could always add a designator to your title. I know some people are wary about changing titles, but if you add something to something so obvious as the title, it'll definitely alert the docketer and the paralegal and attorney that this case is special and needs to be treated differently. Plus, once the patent issues, you can always remove that designator from the title as it would no longer be relevant. So that's the first problem, is flagging it. And then flagging, once you've figured out how best to flag it for yourself, then you'll need to docket it.
So Sean, how would you go about docketing, or would you go about docketing anything differently when dealing with an accelerated examination matter and a due date for that matter?
Sure. Hopefully within your docketing software, you have the country law that's going to have a template that will track this appropriately. A lot of docketing softwares don't have that. So the best practice is to actually go in and manipulate that, let's just say non-final office action, and manipulate the track date to make it a final for that first 3 months. So that way it's going to show up on the paralegal and the attorney's docket as something they really need to act on. Even a better way to handle that is if you have the ability to create your own, well, within Foundation IP, a template that's going to launch that 3 month as a final and track it appropriately. That way you have less risk of having that docketed incorrectly as a due date. Really, it's obviously the 3 months is not a detrimental. It's going to go abandoned, but it really needs to stick out to the attorney and the paralegal on their docket report that they need to act on that 3 months.
Great. So really there's two parts to accelerated exam. One, flagging for the docketer, or not the docketer, flagging for the docketer so they recognize this is what the kind of case they're dealing with. And then that will trigger them to docket it differently if there are not country law rules built in for accelerated exam, and if instead the doctor would need to use a customized activity or change the type of deadline, right?
That's correct.
All right, well, let's go on next to InterParty's reexam. InterParty's reexam requires specialized docketing that's unconventional, and for some firms, it's something they've never docketed before and they've never encountered. So how do you make sure that the docketing gets done correctly in the InterParty reexam matter without upsetting your normal docketing safeguards? Carrie, can you comment on this one?
Sure. So from a docketer standpoint, InterParty's reexam can be confusing in that there are two parties involved, and the docketer may not know if the attorney, your client, is the opponent or the patent owner. Early on in the reexamination stage, the patent office will issue what is called a scheduling order, which will lay out a bunch of deadlines for both parties to respond to. As a docketer, if you're unsure if you're representing the opponent or the patent owner, it's best practices definitely to just docket all deadlines issued by the patent office. And sometimes the attorney might want that anyway, so they can track what their opponent is supposed to be filing. But if they don't, then they can come back to the docketer and tell them to remove those deadlines that they're not responsible for. But best practice, docket everything issued by the PTO, and that way you'll ensure that you won't miss any deadlines.
Great, and you mentioned the scheduling order, so that's a great tip for anybody who has not worked on an InterParty's reexam before. Take a look at that scheduling order because, as you said, it has very detailed information laying out the dates, the timelines, and the overall process, right, Carrie?
Yes.
Let's next talk about how to docket multiple options for responding to a final office action. So as everyone knows, when you have a final office action, procedurally, there are a number of different things you can do. You can respond at the 2-month date, you can respond at the 3-month date, you can file an RCE, you might file a notice of appeal, you might have an advisory action that you need to deal with. So there's many different things. There are a lot of variables looking at final office actions from the standpoint of what needs to be docketed. Sean, can you start off this one and talk about how to docket final office actions?
Yeah, sure. And you pointed out the 2-month versus the 3-month, and I've seen in docketing softwares where sometimes they'll launch the 2-month as a reminder, and I think best practice is always just to treat that as a due date because again, it's going to be more prominent on a docket report to see the 2-month on the final. And then also just making sure your docketing system is launching the notice of appeal separately. Obviously, that's important. You want to track those separately. So when they show up on the docket report, you're seeing them separately. You're going to be responding to the final, and then you're going to keep the notice of appeal on there if you don't file it. So it's important to have them separately. And then, Ann, you mentioned the advisory action. As many of us have experienced, is that advisory action can just be submitted by the patent office, and you could be 1 day away, or you could be on the day of that final 6-month deadline. So it's imperative that those are high priority, same day docketing, and the docketing person is looking at those very closely. It's been kind of an issue, I know, for a lot of people. The patent office issues those and you don't have any time to respond. So they just got to be a priority and something to watch for.
Good. Carrie, anything else to add on final office actions?
Actually, yes. So I'd like to add that final office actions are not only tricky in how you docket them, but in how you close out the responses. Specifically, let's say a request for continued examination has been filed. As a docketer, we need to be aware that with an RCE that closes out all the final office actions. So docket the RCE, but then also we need to remember to close out any pending final office actions, notice of appeal, or that 6-month deadline. Also, another point is if a notice of appeal has been filed, we need to be careful from a docketing perspective about how we docket this. If an appeal has been filed, we need to make sure to close that activity and that the subsequent 2-month appeal brief will launch. If an appeal hasn't been filed, then we need to make sure to close it, but close it in a sense. I know Foundation IP has an option where you can close it with NAR, no action required, and this will just close out the activity and won't launch anything further. So we need to be careful about that if and how we're closing final office action dockets.
Thank you, Carrie, and I'm glad you mentioned how you close out these dates, because the previous webinar in this series was all about crossing off deadlines. And in that webinar, we talked about different ways to cross things off and different terminology. In particular, you mentioned completing, where that typically refers to updating a date when something has been filed, versus clearing, or you use the term NAR, no action required, which is typically referring to taking something off the docket so the deadline doesn't show anymore, but it doesn't mean that the item was actually filed. And that is a tricky thing that people often forget about when they are updating the docket with respect to one of these various options that has been taken after final office action. It's very common that people will forget to clear the other items that are other possible options that were not used at that stage. And those then, if they're not cleared, stay on the docket and become a bit of a pain point for the attorneys who are, or paralegals who are working on these dockets. So I'm glad you mentioned that. That's a great comment. Let's talk now about deadlines for requesting a correction to a patent term adjustment calculation. I put this one on the list for one particular reason, and that's that there may be people who are listening that still think that the patent term adjustment calculation done by the PTO still appears on the notice of allowance, which is where it was for many, many years. Actually, for many, many years, both the notice of allowance and the issue notification would have a patent term adjustment number printed on them. And traditionally, a law firm would check the calculation at both steps, both at the notice of allowance and then again at the issue notification stage. In the well, fairly recently, the Patent Office has stopped putting PTA calculations on the notice of allowance. So that number now only appears on the issue notification. It's no longer on the notice of allowance, and I want to make sure people know that. From a docketing standpoint, then, what that means is the deadline to request a correction for a patent term adjustment that's wrong would be calculated off of the date from, would be calculated based on that issue notification date, as opposed to calculating it off of the notice of allowance date. And I just want to bring that to everyone's attention. Let's talk about docketing deadlines for submission of prior art next. Submitting information disclosure statements is a critical component of U.S. prosecution. However, prior art is often received from corresponding foreign files at inconvenient times and often late in the U.S. prosecution process. So if you get a foreign search report, for example, after you have a notice of allowance in a U.S. case, what are some of the best options for docketing the submission of prior art that comes in late in the U.S. prosecution process? Sean, can you lead us off on this one?
Yeah, sure. And I think to your point, Ann, I think a lot of people have experienced, unfortunately, you pay the issue fee and you realize you missed some prior art, and that's expensive and it doesn't look good to your clients. It can be, there can be a lot of repercussions from that. So what I've seen and what I see as the best practice is you get your notice of allowance, and of course you're going to have your issue fee due. The best thing to do is docket a review prior art, and maybe a week, 2 weeks before that issue fee deadline. That's going to cue the paralegal and the attorney to do one last final review of all the prior art for all the related matters and ensure that they have submitted everything before they pay that issue fee. And so that's a lot of the docketing softwares don't have that built in. It's more of an internal deadline that is the way you'd want to treat it. Again, showing up on their docket report, it cues them to make sure that they have everything covered on the prior art before they pay the issue fee, and they're not going to be facing any ramifications if they miss something.
And that's another good tip. Thank you, Sean. Carrie, anything else?
No, I think he said it best.
Okay. Let's talk now about notices of allowance. Notices of allowance seem pretty straightforward, but they aren't always. And they can be particularly confusing to docket when you have a supplemental notice of allowance or a corrected notice of allowance, or even a notice of allowability that comes separate from the notice of allowance and they're not received at the same time. So, Sean, can you start us off on this one and talk about how to deal with notices of allowance?
Sure. And I think in this slide, you can see the examiners can be confusing. And the patent office in general has a tendency to mislabel things. I've even seen where a notice of allowance came in and the cover sheet looked like an office action, and it was even labeled as a final office action when in fact it was a notice of allowance. So obviously the key here is if you get anything outside of a notice of allowance, the allowability, the supplemental, the corrected, is you look at the docket and the question is, have you received a notice of allowance and has an issue fee been docketed previously, or anything off a notice of allowance been docketed previously? If it hasn't, it's obviously best to err on the side of caution. Go ahead and docket an issue fee deadline based off of the correspondence you received, and then let the attorney and the paralegal take a look at it and question it. And most likely, if it's not clear, they're going to need to contact the examiner and get clarification on that.
Carrie, anything else?
I think Sean sort of touched on this, but I'd just like to clarify that because there can be so many different allowance notices issued, that if anything is issued after that first notice of allowance that's triggered the issue fee, that you don't then docket another issue fee or even change that first issue fee deadline unless it's completely obvious and you clarified with the attorney and the examiner. More often than not, that first notice of allowance is going to be your drop dead issue fee deadline, and any subsequent supplemental allowance issued after that is not going to trigger the issue fee deadline. So you want to make sure that you don't miss that first true deadline.
Well, and again, very good advice from both Carrie and Sean. Certainly, I know it can be a common mistake for docketers who receive something after the first notice of allowance, either supplemental, corrected, or something else, and then they change or redocket to a later date, the issue fee due date, which is disastrous because then you miss your issue fee payment deadline. So again, very good comments from Carrie and Sean on that one. Thank you very much. At this point, I want to remind the audience that questions may be submitted using the Q&A button on the control bar on your screen. I will let our moderator, Brian Ness, let us know if there are any questions and read those questions for us, and then we'll respond. While we're giving people a minute to submit any questions, basically what we've talked about today are common docketing mistakes in U.S. docketing. Really, maybe a better title for this program would have been something to do with tricky things to docket on U.S. docketing, because these are all items that docketers process that have something a little trickier, a little different about it, and that's what we've tried to focus on for this presentation. Brian, do we have any questions in the queue?
We don't have any questions right now, Ann. Do you guys have any final thoughts?
I just want to remind our listeners that the next webinar in the Docketing Excellence webinar series is on December 8th at 1 p.m. Central Time, 1 p.m. Central Time. The next topic is Patent Annuity Pricing Analytics, Deconstructing Patent Annuity Service Pricing. This webinar will discuss pricing and costs for annuities such as agent fees, service fees, and FX fees that are charged. The presentation will go into how to compare these fees between annuity payment services and also discuss how to determine these costs from invoices, even if the invoices are not itemized. To register for this webinar, go to the Black Hills IP website. And I just want to thank our panelists today and thank our audience today for participating. We hope you will join us for this upcoming webinar in December and other webinars in the Docketing Excellence webinar series. Thank you, everyone.